the Water Resources Center Archives and the Center for California Studies. It is my pleasure to invite you to have you here for this California Colloquium on Water. And last year we had a very successful colloquium. We had 8 speakers, 4 in the fall semester and 4 in the spring semester. This year our first talk was supposed to have been on September 11th. Unfortunately, we had a very sad occasion. That talk by Professor Whitney on ecology of Mediterranean climate streams has been postponed, and it will happen here 2 weeks from today, on October 23rd. We have rescheduled it. And today we have a very distinguished speaker who is talking about the human side of water in California. And I have here the Dean of the College of, Dean of both law schools here, Professor John Wyatt, who will introduce our speaker today. And as you see here, the theme of this entire colloquium is to educate ourselves and become basically literate about water in California and all the aspects of water, the science as well as the human side. And just before I ask Professor John Wyatt to introduce our speaker, I want to mention that in this quest for bridging the gap between science and the humanities, our Lee is a good example. He is a well-known expert on property law teachers, and what many of you may not know is that he has a PhD in chemistry from California Institute of Technology. So we now have somebody who bridges the gap between the sciences and the humanities. With that, I request John Wyatt to introduce us.
Thanks. Good afternoon, everybody. It's really a pleasure and a distinct honor to introduce my friend and colleague, Joe Sachs, here as the first person to speak to the colloquium this semester. Let me just tell you a little bit about Joe. Of course, many of you are drawn to this talk precisely because it's Joe who is the speaker today. He has a remarkably distinguished career. After graduating from Chicago and working first for the Justice Department in private practice, Joe entered academia, teaching at Colorado, teaching for 20 years at Michigan, and joining the Bolt faculty in 1968. His distinguished career has not only been in academia, but also in the profession as well. For 2 years, he served as a Deputy Assistant Secretary in the Department of the Interior under Bruce Babbitt, where he had heavy involvement in a number of conservation matters, especially related to water issues. Joe has won just about every environmental award you could win, including awards from the Audubon Society, from Sierra Club, from EPA, and so forth. And it really is, I think, a reflection of his distinctive and important contributions to environmental law and policy. Joe has single-handedly, I think, rewritten or invented important areas of water law, conservation of natural resources, conservation of historical resources, and of course the public trust doctrine, an entire field of law that he relaunched in an important article in 1970. I think it's no understatement at all to say that Joe is the dean of environmental law throughout this country and indeed internationally. And it really is a special pleasure to have him talk to us here today. So I give you Joe Sachs.
Thanks, John. Can I turn off this machine? Because I have no visual aids. Thank you very much. I do not need to use it. Sure. Now, where should I put my elbows while I'm talking? Is there something to lean on? Do I use this? Okay. Yeah, maybe that would be a good idea. Any minute now, I'll get started. Well, I happened to be at a meeting just the day before yesterday, at which the subject, the public trust, came up in conversation with someone who has worked on this issue for some time, and she said, you know, when you talk to people about the public trust, there is usually a lot of confusion and a lot of misunderstanding, and the reason for that, she said, I think is that people don't understand that there are really two rather distinct things that we have in mind when we use that expression. At one level, the public trust is a philosophy, and at another level, it's a tool. And I think that's a very useful way for me to start out, because I think she was entirely right. That is, sometimes when we use the phrase the public trust, we are talking about the relationship that ought to exist between people and resources within the context of our general property system and our notion of the obligations that those who control resources like water owe to the public. But sometimes when we use the phrase the public trust, we are talking about a functioning, powerful, operative legal tool that creates specific duties upon officials and upon individuals, and those are duties that are enforced at law. And those two things are not entirely the same, although obviously the second grows out of the first. And it's important to make sure that we know which of those two realms we're working in. Let me start by saying something about the big issue, the public trust as a philosophy, and what I think it's really about, and then come down to the more concrete level of public trust as a tool. I think it's fair to say that in the large sense, the public trust can be reduced to three ideas. One, that water is, always has been, needs to be a community resource, that it never has been and never can be private or privatized in the ordinary way of other resources. Unlike coal, unlike oil, unlike metallic minerals, there is something special about water, partly, not because all of those, not just because it's vital to life, because that's true of all those things in different respects, but because of its physical nature. Unlike anything else, water moves, and it's used, and it's reused, and it's never the same thing that we use. It cannot be cabined in the way, for example, that we limit and confine an interest in land or an interest in another mineral. So water is inherently a community resource. The second thing about it is that because it is a resource with special claims upon it by the public, its status evolves over time. And its status evolves to accommodate public needs. So when the public trust is implemented as a legal tool, it is implemented as part of a common law tradition. And the essence of the common law tradition is court, judicially articulated rules, judicially articulated restrictions, which evolve over time and are modified to accommodate changing public needs. And third, and distinctively, the public trust is not just a source of authority for the state, but it's a source of duty, a mandatory obligation to utilize trust resources in a particular way for the public benefit. So with those three things in mind, let me say something about the history, the historic status of water as a community resource. First, it has always been, in all places and at all times, a resource with a special obligation to the community. Whether one goes back to the Roman law roots, which are so often identified as the source of the trust, in which public rights in the sea and the seashore and restrictions on the ability to privatize those rights is the issue. Or one goes to the first recognition of the public trust in American law, which was as early as 1821 in a New Jersey case where the question was the privatization of oyster beds in the submerged lands underlying navigable waters, or to what is generally thought of as the great defining case in American law, the decision in 1892 of the Supreme Court of the United States in the Illinois Central case, where the court overturned a legislative decision to grant trust lands into private ownership and held that they could not be alienated out of their obligation to the public. Even in this state, the public trust dates back to, and cases involving the public trust date back to the earliest days in the middle of the 19th century when land was first being filled and developed on the San Francisco shoreline to permit access to waterborne navigation, or to the famous 1913 case, the California fish case, in which the Supreme Court of this state held that grants of trust property must be read implicitly to reserve the public servitude upon the trust, and that even when deeds said nothing about such a reservation, and even when they seemed to grant the fullest property right, that a trust obligation and a limitation on the private owner in favor of the trust must be read into every deed. So the idea that trust resources and water resources are a public resource, that they have always been seen as a public resource, goes back as far as we trace our legal history. Nor is this notion of water as a public resource limited to the trust doctrine. In every setting in which the water systems have been articulated, you find a fundamental restriction on privatization in favor of the public, in favor of public rights. In the Spanish water law system, the Pueblo right gave to communities a first claim on all the water that ran through the community as a first call as against any other rights that individuals could acquire. And that is part of California law. The city, it may come as a surprise to some of you that the city of Los Angeles is a pueblo, and that all the water in the Los Angeles River, including the groundwater tributary to the Los Angeles River in the San Fernando Valley, is part of the right of the people of Los Angeles as a pueblo. And that's the law today, as it has been since the earliest days of the founding of the city. Elsewhere in the Southwest, in New Mexico, for example, The water doctrine involves the concept of the community acequia, in which every member of the community has an obligation to participate in maintenance so that the water is available for the use of the community. Water was established as a community resource by the early Mormon communities in Utah, and the early Indian irrigators in the West also treated water as a special community resource, not an ordinary individual thing. If you turn away from the West and away from the law of water related to the arid region, you find the riparian system, the fundamental water law in the eastern part of this country and in humid areas generally. Well, what is the fundamental principle of riparianism? It is that water belongs to the community in which the river originates. And the fundamental doctrines of riparian law are that only those who are part of the riparian community can utilize the water, that the water cannot be taken out of the riparian community. And it is, it was traditional riparian law that the water was allowed to flow, or required to be allowed to flow as it did in its natural state, so that every person in the community downstream would have the benefit of the water. Now, it is an interesting fact that some of these riparian elements are being revived in Western water law today. That is, the area of origin principle, which we have by statute in California, is a resurgent riparian notion that incorporates or reincorporates anew the idea that the community in which the water arises has a claim on that water that they can assert as against those who are taking the water out of the community. And modern in-stream flow doctrines are a resurgent version of the old idea of natural flow doctrine that represented the community's claim on water under traditional English and early American law. So everywhere you turn, you find this one principle: water is a community resource. Now, let me turn to the second point. The law of water evolves to meet changing community needs. This also is a limitation on the notion of privatization. Let me just take you through the history of water rules in the United States. I started by talking about the natural flow doctrine. The natural flow doctrine was a pre-industrial doctrine, but when industry came, as it did to the New England states in the early 19th century, in order to power mills, the natural flow doctrine gave way, and the courts and the legislatures allowed the law of water to evolve into what became called the law of reasonable use, so that those who needed the water for industrial manufacturing purposes were allowed to stop the flow of the water as long as they did so reasonably in relation to the needs of their neighbors. A fundamental change in the law because the law of water reflects the needs of the community, and the uses that people are allowed to make of water have to adapt to the needs of the community as those needs evolve. As you move west from the New England states and the Mill Dam Acts, you come to the upper Midwest and the cutting of the great white pine trees to build the cities of the Midwest like Chicago. They couldn't get, except during the winter time, they couldn't get the logs to where they needed them by skidding them across the snow, so they had to float them down the rivers. The problem with this, of course, was that the traditional rule of water law was that waters are only navigable, that is to say public, and open to use by anyone if they meet two standards. One, they're tidal, and second, they are used by boats for commercial purposes. Well, the rivers in the Midwest were not tidal, nor were they, for the most part, suitable to commercial navigation by boats. The fundamental definition of navigability under the English common law as it was adopted in the United States. So what happened? Well, the needs of the public to use the water for the flotation of logs brought about a change, and the definition of navigability was revised so that the water did not need to be tidal in order to be navigable, nor did it need to be navigable by commercial ship. And this is what led to what's usually called the floating log test. So it's somewhat of a misnomer, but the floating log test of navigability. As you move farther west, we come to the settlement of the arid region west of the 100th meridian. The law, the only law that anybody had known was the law of riparian rights, which is to say that only those who own land and only those who own land adjacent to a river are allowed to use the water, and only to use it on land within the watershed of the river. This was completely unsuitable to the conditions of the arid West for a variety of reasons. For one, people didn't want to use the water where the rivers were. They wanted to use it elsewhere, first for mining and later for agricultural irrigation. And even more importantly, at the time the settlers first came, nobody owned any land because all the land was still in the ownership of the United States, and these people were permitted or tolerated trespassers on the public domain. So the question arose, what about the Riparian Doctrine? And the courts, beginning with the Supreme Court of Colorado in 1882 in a case called Coffin against the Left Hand Ditch Company, said there is no riparian law in Colorado. The law of water rights in Colorado will evolve and adapt to meet the needs of the public in order to promote the public purposes for which people are here. And the law is the law of imperious necessity. An imperious necessity in a riparian, in an arid region, is the law of what we all know now as prior appropriation. In 1929, in California, I've now moved as far west as I can, where we adopted both riparian and appropriation doctrine, and they existed side by side. There was a traditional right that all riparians held, which was a right to use all the water that flowed by their land, as long as they could make some beneficial use of it, no matter how extravagant that use was vis-a-vis others who wanted the water. And so people used water for natural, what's called natural overflow irrigation, just allowing the lands to be flooded, because that was the cheapest way to get the land onto the water. But this was very disadvantageous to others. And so, once again, the law of water rights evolved. California changed its constitutional provisions in 1929 and mandated that all uses must be reasonable and beneficial by the standards of the time, and those traditional rights of riparians were abolished. It was also the law in the West. In fact, it was a fundamental principle of water law in the West that you must make a beneficial use of water, and that the only way to make a beneficial use of water was to use it to promote the economy by diverting the water out of the stream rather than wasting the water and letting it run into the sea. And that proposition held as a fundamental rule of water law for well over 100 years. But in our own time, as the values of maintaining in-stream riparian and fish life rose to become an important public goal, that rule was abolished. And of course now, in every state, in-stream flows are treated as beneficial uses. So of course we've, in a certain way, come back to the natural flow doctrine. But as you go through 200 years of water doctrine, you see that in each place and in each time, as new needs arose, the definition of what rights people could have in water changed to accommodate to what were the identified needs of the public. And that is the ultimate essence of the public trust philosophy. Let me turn now to say something about the public trust as a tool, that is the doctrine of the public trust as it is actually implemented in the law today. Again, you will see this evolutionary process in play. In the old cases, in the oldest cases, such as the 1821 New Jersey case that I mentioned, or the old Roman law cases, the focus of the public trust was on bottomlands, that is, on the submerged lands beneath navigable waters. And that has given some people the notion that the public trust is about tidelands, for example, that it's about land and about submerged lands, but it's not. It's a doctrine about water. The reason that the old cases involved bottomlands was because it was believed in those days, in the days before modern regulatory government, that the way to make sure that you could protect uses in the water, in the overlying water, was to own the land underneath the water, that the key to government control of the water for the benefit of the public was proprietary. That probably seems peculiar to people today because we think it's natural for government to regulate even when it doesn't own things, but that wasn't a very widespread view back in these olden days. So when you look at those old cases, you find that they're about submerged lands. And the second thing you find is that the public interest as it was traditionally defined under the public trust was for 3 or possibly 4 purposes. It was to promote public navigation primarily and to promote waterborne commerce. And that's why the doctrine focused on navigable waters. And it was to promote fishing, and at least in some of the New England states, fowling, with a W. In the same sort of process of adaptation, the California public trust doctrine changed dramatically. Probably most people think that the great moment of change was 1983 when the Supreme Court of California decided the National Audubon case, or the so-called Mono Lake case. But actually the most critical change, I think, came about a dozen years before Mono Lake, when the California Supreme Court decided a case called Marks against Whitney. And the reason is that Marks against Whitney said for the first time ever, the public trust is not just about navigation, commerce, and fishing. It's also about environmental protection. I have a brief quote from the case. The public uses to which tidelands are subject, the court said, are sufficiently flexible to encompass changing public needs. Preservation of these lands in their natural state so that they may serve as ecological units for scientific study is essential to the public trust. This was a dramatic change. Public trust had never before been used. But you see, in 1970, environmental protection and the protection of natural areas had become as central a public purpose as navigation and the promotion of commerce and the building of the port of San Francisco or Oakland had been 100 years earlier. And so the public trust evolved to meet that need. When Marks against Whitney made this decision, it set the stage for the Mono Lake decision. Because Mono Lake, of course, the Mono Lake case was not about navigation or fishing or fouling. It was about protecting the natural values in Mono Lake, and that now had been legitimated by the Supreme Court. But the court in Mono Lake had another problem, and that was that because of the traditional setting of the public trust, that is the setting in navigation, it had always been understood that the public trust was about navigable waters and the lands beneath navigable waters. But the water that was being abstracted by the city of Los Angeles were not navigable waters. They were the non-navigable tributaries of Mono Lake. And so the court turned the wheel one more time and said, that's all right. To protect the interests in navigable waters, we can go to the tributaries of navigable waters. And while that seems, I suppose, the most commonsensical thing, it was a big change for the courts to be able to move from navigable waters themselves to those things upon which navigable waters depend. About a year ago, almost exactly a year ago, the Hawaii Supreme Court decided a case that may turn out to be as significant in its own way as the Mono Lake decision and Marks against Whitney that preceded it, because the Hawaii court has now gone one step beyond where California had been. On the island of Oahu, when the sugar industry closed down, which had diverted virtually all the water from certain streams on the wet or windward side of the island through tunnels onto the dry side of the island in order to irrigate sugar. Since about 1912, leaving very limited water on the wet side of the island. When the sugar industry closed down, the people who had taken all that water had to come back and apply for a permit to change to some new use that they might want to make of it. And at this point, a claim was made that these waters should be treated as part of the public trust, and the public trust should be applied to these waters. Well, this presented some problems because First of all, the tunnels were taking water, groundwater, the public trust had never before been applied to groundwater. But the Hawaii Supreme Court said, under the circumstances that are now present, all water, including groundwater, is held in public trust. And of course, that groundwater was feeding the non-navigable streams on the windward side of the island, which were supporting the fish and other resources in the estuary. So there was a linkage from the navigable waters to the non-navigable tributaries to the tributary groundwater. The Hawaii Supreme Court also made a few other innovations that have not yet garnered as much attention as they soon will, I think. It said that the public trust also can be applied in order to meet the needs of indigenous people who have a fundamental right to water for certain uses, and also can be applied, can be appropriated for the purpose of meeting traditional and customary uses. So that something that we have been on the mainland trying to deal with through the so-called doctrine of reserved rights, rights that were reserved to Native American people at the time reservations were created, is now being incorporated, at least in that state, into the public trust doctrine. The leadership that was first exercised by the Mono Lake case has now been built on in Hawaii. It has been adopted by the Supreme Court in Idaho, which followed the Mono Lake decision. There is also an opinion, although not yet an opinion of the majority, because they haven't yet gotten there, but in a opinion, what's called a concurring opinion of two justices of the Nevada Supreme Court, citing both the Mono Lake and the recent Hawaii case. All of these cases now taking the position that ordinary appropriative uses of water in the West, which have traditionally been used for primarily for agricultural irrigation, are now subject to re-examination in the light of contemporary values, societal values, and have to be examined in the light of the public trust values. And this brings me to one more element of this public trust as a tool, which is an unusual feature of our public trust law. And that is something that the court recognized in the Mono Lake case, but actually had been part of California public trust law since the early days of offshore oil development back in the 1920s. And that is, the public trust is a continuing obligation of the state. And no rights in water can be acquired that are permanent as against subsequent continuing future re-examination in light of public trust requirements of the time. So that this notion that I've been trying to describe of water doctrine as evolving, water doctrine as reflecting over the years and over the decades and centuries the fundamental goals of the society of that time, now has been built into the public trust so that uses, even established uses, as was the case with Los Angeles in the Mono Lake case, as was the case with the sugar industry in Hawaii, are subject to re-examination. And of course, one of the goals is to try not to create disruptive effects, even in good causes, that are damaging to important uses, whether they're environmental uses or economic uses. So that in the Hawaii case, for example, although the decision is a far-reaching one, it's interesting that it was only at the time that the sugar industry closed down and those uses were no longer needed, that the court took up this re-examination in the context of the public trust in order not to create a crisis of jobs and a crisis for the conventional economy. Where are we going now? What's next? I think if I had to make a guess about where the next steps in public trust are likely to go, this would be my guess. I say this with some uncertainty, but if you think about it, the public trust is sort of moving up from navigable waters to non-navigable tributaries and to tributary groundwater. It's moving up to the sources, and it's doing that in order to protect the values in-stream and downstream. And one of the places you have to look to protect values in-stream and downstream is upland, to those land uses that are potentially having the same kinds of adverse effect on in-stream trust values as some of the uses of the water or some of the uses of the submerged land itself. So I suspect that in the next round, and no one can say exactly when that is likely to happen, we will begin to see claims made that land use plans need to take into account, particularly for activities like timber harvesting on uplands within the watershed, need to take into account public trust values. There are, of course, lawyers always like to look at precedents, and there are some precedents for this in New Jersey, which has been an active public trust state. The court has on several occasions said that the public trust can move up the beach above the traditional high water mark to the dry sand beach for the purpose of promoting public access to recreational activities in the trust waters. So they've moved upland, not for the purpose of protecting in-stream environmental values, but for the purpose of protecting water-related recreational values. There is a decision in the Supreme Court of North Dakota that goes back several decades now that said that in the devising of the state water plan, account had to be taken of public trust values, so that there is at least some precedent for moving trust into the planning process. These cases that I've been talking about, the recent Hawaii case, the Mono Lake case itself, although they are now either well established or in the process of being established and recognized, they are very far-reaching cases. They are dramatic implementations of this doctrine of evolution and change. I think it's important myself for the continued appropriate development of the public trust as a tool, and not just as a philosophical construct, that one be cautious in the way that the Hawaii Supreme Court was cautious. That is to say, not to use the trust doctrine as a disruptive force, even for important and desirable public purposes, but to find those times and those opportunities when these shifts can be made in a way that are transitional and evolutionary rather than disruptive and evolutionary. But if we do that, I think we'll see that as time goes on, the tool, the functional part of the public trust will begin more and more to blossom out to represent the full range of possibility of the trust as a philosophical premise about people, resources, and property. Thanks.
We have ample time for questions and comments.
Could you give some examples or has the public trust doctrine as a tool used disruptively?
Well, it depends on who you ask. It's a very important question. If you asked, if you went back to the mid-1980s and asked the people who were responsible for Los Angeles water supply, they would have said this is enormously disruptive because this is a fundamental part of our water supply, and what are we going to do now? That is, I'm sure most of the people in this room know, one of the ways in which the restoration of Mono Lake was facilitated was by going and getting appropriations of money to help Los Angeles transition to other sources, to put into place important conservation use procedures so as to keep that crisis from happening. So what seemed like it was going to be very disruptive, I think in terms of the remedy has turned out to be a smooth transition. It's actually done some very good things, and of course Los Angeles now very proud of all the progress that they've made, and I mean properly so, thinks of themselves as exercising important leadership in terms of conservation in domestic municipal use.
Joe, can you talk about his next steps in terms of, there are 3 areas in California that I see still need to be clarified. One is to the pre-14 Riparian Rights. I assume that's pretty straightforward. The one that's more challenging for me is the artificial irrigation ditches that have taken on the qualities of a natural stream. You see that. And there's one in Mono Basin, Mike.
Yes.
And it's also on the west side of the here, I'm sure some of the hydraulic money ditches have taken on characteristics of the natural stream. Do you see the public trust potentially being applied to that and protecting those natural characteristics of these artificial ditches?
As you know, there has been a suggestion, there is a case in which there was a suggestion that the public trust cannot be applied to any artificial facilities, that it could only be applied to, quote, natural facilities. But of course, if you think the public trust is a water doctrine, and you applied it only to, quote, natural facilities in California, we may as well shut down the shop because there isn't much that hasn't been modified in one way or another by human intervention. So I would say that when the question arises, I'm confident that the fact that the setting is, quote, artificial, will not be a bar to trust implementation.
reading 314 and riparian or fair game? Because the Audubon decision was to incorporate it, close to incorporate it, but
Yeah.
nothing in their reading.
Well, as you know, the California Supreme Court in the Long Valley case has, I should preface this by saying, riparian rights in California are recognized in the Constitution. And although California is now almost alone among Western states in continuing to recognize riparian rights, they've been abolished in most other Western states that adopted them. The California court has held that you could not constitutionally abolish riparian rights, but in a kind of legal sleight of hand for which judges are sometimes famous or infamous, the court said, well, we can't abolish riparian rights, but we can subordinate them to other rights, either before or after. So I think it's fair to say that riparian rights, insofar as they are viewed as interfering with reasonable and beneficial use, are fading from view.
You've commented in terms of this next round of possible expansion of scope, and the Hawaii case certainly proves that. You also talked a lot about expansion of existing scope to other jurisdictions, Nevada, potentially Idaho. I wonder if you could comment on the applicability of these doctrines, which so far have been decided from state courts, to federal agencies, FERC, particular vis-a-vis federal legislation.
Yes. Not promising. This is a question that has not ever been decided by the U.S. Supreme Court, but the general view, the general understanding is that the public trust is a state law doctrine, that it is an element of the sovereignty of the states, and that the states bear an obligation to implement the trust as a kind of sovereign responsibility. And some courts have read that into the state constitutions. And as I mentioned, in Arizona, in Illinois, the courts have actually overturned legislative enactments on the ground that they violated the public trust. The Supreme Court of Washington has spoken in the same terms just recently, in 1998. So this is a very important element of state law, and each state evolves its trust doctrine in its own way. I mean, I've mentioned the strong public trust states. There are also a couple of weak public trust states like Maine and New York, which have been very ungenerous in interpreting their public trust. The view that has been expressed so far by the lower federal courts is that the only obligations the United States bears in this regard are those that have been explicitly recognized by Congress in statutes, so that you must look to federal statutes to see if there are any federal trust obligations. Congress does sometimes speak in trust terms, not only about water, but, for example, about parks sometimes. The Redwood, there are some quite notable cases involving the Redwood National Park where the court spoke in terms of trust obligation to protect Redwood Creek. So I would say that's unpromising. The only area I can think of where if I had to do it, you know, I mean, if someone was actually forcing money on me, you know, to bring a federal trust case, I have one good case, I think, and that is oil drilling in federal waters beyond the state limits, because the notion is that the navigable waters are protected within the states by the state trust. But as soon as you get outside there is no trust protection, because the public trust, these submerged lands beneath navigable waters were given to the states by the United States in order to implement the trust. And that's the whole theory, you know, is that the United States, which was the sovereign and owned everything, except in Hawaii and Texas, which are not public land states, but in all the other states, also except the 13 colonies, but anyway, in most of these states, in the public land states, the United States was the sovereign. It was also the owner of everything, land, water, and everything. And that it held, this is what the court has said, it held the submerged lands as a trustee for the states, awaiting their sovereignty. And at the moment that the state entered the Union, all the land beneath navigable waters passed to the state in trust for the purposes we were talking about earlier. Okay? Well, how about the waters within the United States, within the jurisdiction of the United States, but outside state limits? See, there's no discussion of them. So that would be the most attractive case you could have. And of course, Congress has given some, passed the statutes to protect it. But you might argue that that the United States remains a trustee for these lands that it has never granted because they're outside the jurisdiction of the states. But that would be the best case. That'd be your best. Got a 22% chance of winning.
After spending part of the summer in White County, helping them deal with the aftermath of the public trust case, they sent me a message to ask you this question, and it is that you have been reported to have said that the public trust doctrine is a blunt instrument. Can you expand on that?
Who said that? Who said that? I mean, who says that I said that?
Jim Anthony.
Oh yeah. I don't recall saying it's a blunt instrument. I mean, I think it can be a powerful instrument, and I think it is, and it should be a powerful instrument, but.
Well, he did say reported, so maybe he never reported.
No. Actually, I heard that.
You heard me say that?
Yeah, you said it was perhaps too blunt an instrument. And in talking about California and so in the water colloquium, it was a water working group meeting, and.
It's hard for me to believe that I said the public trust was too blunt an instrument. I mean, that's what got me tenure, was a public trust doctrine.
Okay, at the same time, now are you working with the Imperial Irrigation District?
Am I working with it? No, I'm not working with the Imperial Irrigation District.
Why don't you just comment on whether it is or isn't one that's
I wouldn't, I mean, if I said that, I may have said it, but I don't remember saying it. It is certainly not my view. If I said it, I don't remember the context in which I said it. I would say it is a powerful instrument. I think, and I also think it's a necessary and desirable instrument. I mean, I hope that was the message that I sort of got across. In the wrong hands.
Can you comment on any role the public trust doctrine has played in the Klamath River Basin?
Say that again. I'm sorry.
Comment on the role that public trust may have had in the Klamath River Basin happening to the last.
None that I know of, and the reason for that is that I think that the crisis, if you want to call it that, in the Klamath was generated by two other powerful instruments, the Endangered Species Act and Indian reserved water rights. Both of those have some of the same kind, can make and do make some of the same kinds of demands that the public trust doctrine today does in a state that recognizes Mono Lake type things. That is a demand for leaving more water in stream or bypassing more water. Let me just say something about the relationship between these two things, because that is, those kind of laws and the public trust. One of the advantages of the public trust doctrinally is that it is a property doctrine. That is to say, what I was trying to say in my talk earlier was the essence of the public trust is that certain rights are reserved and retained by the public and can never become privatized. So that if under trust doctrine you would require people who had been diverting water to leave some of that water in the stream, okay, I would say they would not be well positioned to make a claim that their property rights had been invaded, because you're asserting a reserved right, proprietary interest in the public. Whereas one of the claims that's been made in these Endangered Species Act cases, in the Tulare Lake case recently, is that if you require people who have contractual rights, this was under the State Water Project, they have contractual rights to receive water under the State Water Project or under the Central Valley Project, and you require them to bypass some flows, that you are diminishing their existing property rights and they would have to be compensated. So I mean, that's one of the advantages of using public trust if you have that choice.
I'm interested in finding out how public trust doctrine case laws can be used by communities. City attorneys are not willing to put public trust in their tree protection ordinances because they say it's not in the case law. And I understand that according to them, that the monolithic decision, it does not qualify as based on the adjudicated in the courts, it was adjudicated within the State Department of Water Resources. I'm wondering if you can tell me how you get from A to B on this, because that doctrine isn't being used on a local level, and it needs to be.
Well, first let me say, the Mono Lake case was adjudicated in the courts, and it is a decision by the Supreme Court of California, which is the highest judicial authority that we have. So if what you reported is what these people are saying, of course sometimes people are misquoted. If that's what they're saying, that's erroneous. It is sometimes difficult to get local or other governmental officials to pursue the public trust because it is a controversial doctrine, because it's common law and judge-made law. It doesn't sometimes have the exactitude of language, you know, that you can go to an ordinance or a statute. But I don't think there is no doubt that it is, at least in proper circumstances, it is part of California law, and there is a requirement that it be implemented, and I think all you can do is just keep urging people, and you will eventually succeed, you know.
Well, in the case of
persistence works.
well, Buda Creek was, people along Buda Creek were asking for more water from the Yolo County Irrigation District, so that the fish could survive. And they won in the lower court.
Yes.
When it went to appeal, it didn't win, and therefore it can't be considered case law. So what I'm curious, how does, I mean, is there any mechanism other than going through that process that there is for getting something in case law so that there's also...
Yeah, well, yeah, I mean, there is, under California law, private citizens have what we call standing, you know, authority to go to court to enforce the public trust doctrine, and the Supreme Court of California so held in Marks against Whitney. So it is possible. I mean, this may not be, you know, a burden that you or your associates want to bear, but I mean, it is possible. Another advantage of the public trust as a powerful doctrine is that it does authorize you as a citizen, as a beneficiary of the trust, to bypass reluctant or recalcitrant public officials. You know, it's a heavy burden to bear, to go to court and to follow through, and you know, it's no easy task, but
pertaining to this side.
For the Creek case, water table is settled and the appeal was dropped. So there is no, that's what happened.
Oh, I see, okay.
And in the Water Lake case, of course, the Supreme Court didn't determine the amount of water. The water.
No, no, no.
So maybe that's what she's referring to.
I see, yes. Yes, ultimately, the ultimate resolution went back to the water.
Okay, next question.
Building on your comment that the doctrine may become a tool for land use planning, do you have any thoughts on how courts may or how they should balance traditional uses with the more recently recognized uses when they come into conflict?
Well, it's hard to answer that except in a kind of general way. What I was trying to say earlier is I think it's important to try to find an accommodation that is not disruptive. Okay, there are a lot of tools that you potentially have at your command for these things. That is, sometimes it's possible to find water-saving mechanisms that will effectively increase the supply that you have, because we still have a lot of old systems that are extravagant in their use of water, even though they may not technically be wasting water. Sometimes it seems to me it is appropriate, as in the LA Mono Lake case, it's appropriate for the public to help, to provide some subventions to help implement new technologies, for example. Sometimes, I mean, there are all kinds of things that we can do to effectively increase supply. I mean, we were talking with some people earlier before the session began about efforts to store water underground, in aquifers, so that you can take advantage of years of higher flows without having to build new dams and reservoirs or to raise existing reservoirs. I mean, as we can do more of that, we may find, you may effectively be able to increase your supply. So I think we have to look for those kind of things. I mean, there are a number of instances. I mean, we've had some post-Mono Lake cases in California, that have been resolved. One involving the East Bay mud, so that there are some resolution. You don't want to do more harm than good, or do good by doing harm. I mean, it's not good law and it's not good public policy, in my opinion.
That addresses an example I hadn't thought of, but I'm thinking more specifically on an area like Oakland's port facilities and the increasing pressure to protect the shoreline resources and where two legitimate uses directly conflict. Any thoughts on whether or not a traditional use carries more weight, or whether or not there's an evolution towards putting more value on the environmental side of things?
Well, I don't know exactly what two uses you're talking about, but I mean, you can adapt some traditional uses in shorelines, for example, to provide increased public access, which has often been cut off in a lot of these traditional uses. You can sometimes take back. I mean, we have a whole lot of public trust issues of that kind with the closing of all the military bases around the bay, all of which present public trust issues of various kinds, whether it's Treasure Island, Mare Island, or is it the Oakland Army base, I guess. And there are opportunities there for public recreation and so forth.
Richard?
You mentioned the general philosophy of the courts was to
speak up.
You mentioned the general philosophy of the courts was to make decisions when it was convenient, when the time was right, force a lot of the country to come about and do maybe too much too early. How do they stay sensitive to that?
How can you be sensitive to that?
There's not too much moving upstream too soon. Make a decision on groundwater. Might inconvenience the wrong people. And how many, you said before, the general philosophy is to wait for the time and convenience. And mean, how are they?
Did I say convenient? Something like that, yeah. Well, I don't know. I don't know what else to say other than to try to give an example. I gave one example with the Hawaii case where you've got a change of use. I think, for example, as you see some of these efforts for water marketing to move water around, that's a moment of transition that I think can be an opportunity to acquire some additional water in stream, for example, when you're making a change. I don't know beyond that.
Speak up.
Yeah, I'm sorry. It's hard for me to hear.
Sure. After hearing about the Hawaii case and the fact that it touches on the groundwater, there's a whole line of cases with the city of Pasadena and the physical solution in which it basically represents the public trust doctrine in a lot of ways. Physical solution being that you provide based on need, everybody, overliers and
right.
others. Okay. So I'm wondering, after the Pasadena cases, they had the Monterey agreements and a lot of the problems, and basically went back to overliers getting precedent over appropriators and others. How will this conflict with the Hawaii case? And it seems like they're sort of converging since the Hawaii incorporated groundwater and all of the Pasadena and following Monterey to groundwater. I'm wondering what happens to the states getting each other.
Yeah, well, of course, the Hawaii case is not the law in California, and where exactly California is going to go. You're talking about groundwater basin cases. Where exactly California is going to go with that is hard to say. The court, as you of course know, the court recently in the Mojave case reaffirmed that overlying owners, people who are pumping groundwater and using it on the overlying land, have a prior right, and that was the traditional law in California, and that appropriators are secondary. I mean, basically, basically that's a money problem rather than a trust problem. That is, the question is who is going to have to bear the economic burden of the shortage or of the cost of bringing in additional supplies, or who's going to have to pay, the tax, that sort of thing. So that's, I don't view that as myself raising a trust issue.
What do you think the difference is between the public trust doctrine and the state asserting its police powers to protect water resources for the general welfare of the people? I'm thinking in particular of groundwater in New Mexico and some of the western states where in the Constitution or in groundwater management acts they've asserted the general welfare that needs to be protected.
Yes. Yes. Well, I think the best answer I can give is that they certainly overlap to some extent. That is, there certainly are things that we do under the public trust, or would and could do under the public trust, that could also be done under the police power. But as I said earlier, the one great advantage of the public trust is that it has a proprietary element that is proprietary in the people. And as there's been more and more concern in the courts, as well as in some sectors of the public, about property rights and government regulation as interfering with constitutionally protected property rights, if you are within the ambit of the public trust, that insulates you, should insulate you, either wholly or very significantly, from property rights claims.
Reportedly ended your speech, your talk tonight, by saying that as the public trust as a tool emerges and becomes broader, it will, what can dovetail or move in closer to
sort of fill that empty space in the philosophy. Yeah, it was a pretty crummy metaphor, but I did the best I could.
So the philosophy has to do with people's relationship with their resources. Now, if it isn't the public trust that can be called upon in, say, the court of public opinion, what can be used, or what ideas do you have for people to begin to protect things like the spectrum of airwaves, university research, the genetic map, those kinds of public assets?
Yeah, I mean, I think that's a very important question. I mean, my own view, as I originally thought about this when I was first writing about this now 30 plus years ago, was that what was most interesting to me about this, about discovering this old doctrine, was not so much its specific application to water and so forth, but the idea of it, that there was a kind of public claim on certain kinds of resources, in which I would include things like scientific knowledge, and that if we could just take this idea, and sort of infuse our law with it, we would have a much better balance. That we have this notion, America more even than most other countries, that everything can be privatized. My own view is that there are a lot of things that it's perfectly appropriate to privatize them to some extent, as we do with water, but that there remains a kind of public claim on them, okay? All right. In terms of the law, as it exists and its capacity for expansion, a lot of these things are not there. I mean, they would have to be done anew. My own hope would be that as this larger idea of public trust, if that can be communicated to people, then we ought at some point to be able to persuade reluctant bureaucrats and reluctant legislators, that there are some things we can do. I just was a few weeks ago at a fossil conference, and saying my own view is, that we should try to persuade legislators that fossils in the ground that have great scientific value ought not to be treated just like anything else that's in the ground, that they belong to the scientific heritage of everybody. And we ought to at least we ought to regulate their excavation. As it is now, you can just go take whatever you call these things, a bulldozer or thing, a trencher, just dig up your own land and dig up the most valuable sources because they happen to be on private land. Well, I think at least, without intruding very much on people's property rights, at least to do things like saying you can't excavate without informing the government. You at least have to give an opportunity so that people, with scientific knowledge can come out and take a look at the area, that there'll be some regulation of the way in which this is done so that its contextual values aren't destroyed. I mean, I think we could do all those things with not under the existing public trust doctrine, but we at least ought to be able to persuade our legislators to take some modest steps like that for things that everybody agrees are important. I mean, people are very polarized about a lot of environmental issues, which I've spent most of my professional life on. But some of these things, like scientific knowledge, everybody agrees that these are important. Everybody agrees they're part of a common heritage. But we don't do very much, to protect them, because as soon as you say private land, everybody freezes, because we have this fixity about the total privatization. It isn't to say that it's not subject to, the police power, but we're fearful, we're reluctant to do these things. And when this case, this dinosaur suit case came up, to the Federal Court of Appeals, they said exactly in so many words, this specimen in the ground is just like a lump of coal. It has the exact same legal status as a lump of coal. Well, you know, they may both be fossils, but they shouldn't, I mean, they shouldn't be the same, you know. And you can quote me.